Aloha, folks, and welcome to this edition of Five Questions. Again, an opportunity to chat with folks about the news of the day. And today we're delighted to get together with Jeff Mateer, who is the General Counsel for Liberty, the Liberty Institute. And I want to thank you so very much for being with us. Jeff, aloha to you.
Oh, thank you so much. Glad to be with you today.
Jeff, we're here on KHVH Radio and also HawaiiReporter.com. And with Five Questions, we always like the first one to be to tell us just a little bit about yourself, if you wouldn't mind, and, of course, the Institute.
Sure. I'm a 21-year lawyer. I've been practicing for 21 years. For the first 19 of those, I was in private practice, doing primarily commercial litigation. About 2 years ago, I joined Liberty Institute as its general counsel, where every day I get to defend religious liberty.
Excellent. Where do you hail from?
Originally from central Pennsylvania, went to law school down here in Dallas at Southern Methodist, and met a girl from Fort Worth, and we've been married for 24 years with three teenagers, and live in the Dallas area.
Well, that's wonderful. I actually have our kids in studio with us today. If you wouldn't mind, I can send them on over to Texas. Maybe you could take over raising them. They're 8 and 10.
I've been through those years. I've got mine. 2 are now in college, and 1's a junior in high school. So we're real happy with where they are.
You're well on your way. By the way, you got our football coach over at SMU.
Yes, and very pleased with him. SMU, good things are happening at SMU.
Yeah, love to hear about June Jones and all that he's doing. Well, listen, I want to thank you again very much for joining us. Really, question number 2 jumps into Liberty Institute, and that is, there are a myriad of issues, Jeff, of course, that faces today, and one organization inevitably is seemingly involved with the debate on these issues, and that's the ACLU. I'd like to get your thoughts about the ACLU as an organization and how they may have negatively affected the objectives that are set forth by the Liberty Institute.
Well, I think the ACLU is pushing a left-wing agenda where they can't win at the ballot box. Often, what the ACLU is doing is pursuing litigation in order to impose their views on our country, and so we kind of view ourselves as sort of the anti-ACLU in the sense that where the ACL turns up and is pushing this left-wing agenda, we are in turn fighting back and really pushing for the founding principles, the principles that our great nation was founded upon, and really seeking to preserve and restore those where they've been taken away by the courts.
Is there a case that either recently or in the past that kind of personifies that, where the ACLU truly was pushing that agenda, and how perhaps you and the organization intervened?
Well, I think one of the ones that comes to mind right away is the ACLU and its friends on the left have been pushing hard to remove public displays of religion from society. One of the cases that we've been involved in involves a veterans memorial out in the Mojave Desert, which is in the form of a cross, which was built during World War I, which honors our veterans and was put up to honor veterans who served in World War I. And the ACLU and its friends brought a lawsuit seeking to have that cross torn down, and it unfortunately went to the Ninth Circuit, which the court there in the Ninth Circuit declared it unconstitutional. But fortunately, we were involved in the appeal to the U.S. Supreme Court, which held that cross was constitutional, that it was okay to use religious symbols on public land to honor our fallen veterans. Was that
in the Ninth Circuit? Was that a 3-judge panel, or was that the entire court?
It went up originally a 3-judge panel, and then went in banc, and then ultimately appealed to the U.S. Supreme Court. Now, what's disturbing about that case at the Supreme Court is a 5-4 decision. And so, one judge going another way, and we would have a decision out there that declares public displays of religion, like crosses, unconstitutional.
I know this is a 5 question. I just want to dovetail on that for a moment, because you're absolutely correct, and that is the 5-4 decisions, and usually Justice Kennedy is the swing vote. If, with the composition of the court as you see it today, and with Justice Kennedy, are we in store for more 5-4 decisions with Justice Kennedy holding sway?
Well, it's often been said, and I think think this week in a national newspaper, talked about this being the Kennedy Court, which is uncommon because usually you call the court by the name of the Chief Justice. He has a lot of sway in cases. Just yesterday we had a religious liberty case argued, which again in this Hosanna Tabor, the ministerial exception case.
Right.
And it all could weigh in the balance with Justice Kennedy. I tell my political friends, presidential elections really do matter because that appointment to the Supreme Court is extremely important in shaping the next 10, 20, 30, 40 years of our country.
Yeah, and unfortunately, it's kind of a hit and miss sometimes, as Ronald Reagan discovered with Sandra Day O'Connor as an example, yeah?
Yes. I mean, unfortunately, it seems like Republican presidents have done a worse job at appointing and nominating judges than liberals. But I would say that President Bush and some of the recent appointments that we've gotten eventually to the Supreme Court have been outstanding judges. I think Justice Alito is by far one of the best judges that we've had in a long time, and he fits nicely with Justices Scalia and Thomas and Chief Justice Roberts.
Chatting with Jeff Mateer for this edition of 5 Questions. He's General Counsel for the Liberty Institute. Where can we find Liberty Institute, Jeff?
Yes, we on the World Wide Web, like everybody, but it's www.libertyinstitute.org. So libertyinstitute.org.
As a matter of fact, let's go to question number 3, really. And you are involved and have been in a very in many legal cases, as you alluded to. And tell us about a case where the First Amendment was at stake in a recent case in the Fifth Circuit Court of Appeals. This had to do in regard to faith at school. And as an example of the work that you do, can you tell us about this case and what transpired?
Yeah, it's called the candy cane case because it involved a elementary student by the name of Jonathan Morgan, and Jonathan decided that for his school's holiday party, they had renamed it from Christmas, calling it a holiday party, that he was going to bring and hand out to his classmates during the party time candy canes, actually pencil pens shaped like candy canes, which included a tag on them that explained the legend of the candy cane and its origins, which does have a religious significance to it. And students were encouraged to bring whatever they wanted to. So Jonathan decided with his parents that he was going to do that. And when he decided and attempted to hand out his candy canes, they were taken up by the teacher, and he was told that he was not allowed because you're in their words, not allowed to have religious items at school. This case has had a long path. It's been going on for several years, but eventually the school district and the government officials, the school principals, moved to have the case dismissed. That was rejected by the district court and went to the Fifth Circuit Court of Appeals. And at the Fifth Circuit, the school officials, attorneys argued that elementary students did not have First Amendment rights. Therefore, the case should be dismissed and the principals immune from liability. Fortunately, that 3-judge panel rejected that argument, and they held that, in fact, that elementary students, like we believed people had known for several years, did have First Amendment rights. Unfortunately, that decision was appealed to the entire Fifth Circuit, all 16 judges, and we just received an opinion which, while upholding the constitutional right, that in fact affirmatively a majority of the court saying that elementary kids do have First Amendment rights, unfortunately a majority of the court also held that the school officials were immune from suit in this lawsuit because that had not been clearly established.
So bittersweet.
Yeah. I mean, it's sort of we maybe lost a battle and won the war. I mean, the big principle in the case was it is now clear from going forward in the Fifth Circuit, which encompasses Texas and the bordering states, that in the Fifth Circuit it is clear that our public school children do have First Amendment rights.
Talking with Jeff Mateer today, General Counsel, Liberty Institute. Thoroughly enjoying the conversation indeed. Whenever I can go to question number 4, and more of a more of a subjective question, I believe, and that is, what is your legal assessment of the Obama administration and especially of Attorney General Eric Holder? Your opinion at large of the legal prosecution of our Constitution under this president, and if you'd like to comment on the latest revelations regarding Fast and Furious, please do so.
Yeah, I mean, this administration has really caused the Department of Justice, which ultimately the president leads and Attorney General Holter is in charge of. It is by far the most political of any administration in my lifetime, and since I've been involved, the last 20 plus years, they have politicized. They're pushing a liberal left wing agenda. And like their friends at the ACLU, they seem to be what they can't win at the ballot box, then they're trying to impose through their administering the Department of Justice. I think just two examples come to mind. The first has to do with not enforcing, not protecting federal law, and one would be the Defense of Marriage Act. Mm-hmm. This administration, on their own, there's a law which defines on the federal level marriage as between a man and a woman. This administration, that is the law of the land. That is the federal law. This administration has decided that it doesn't like that law that was passed by Congress and signed by a predecessor president. And it's decided, Bill Clinton, by the way, and it's decided, this administration on its own has decided that we don't like that law, so we're going to work against. Not only are they not going to uphold it, they're going to work against it. That's political. That's playing to their left-wing base, and you've got an administration deciding what laws they are and are not going to enforce, and that's outrageous. The other example, and it's the case that was argued yesterday at the Supreme Court. We've got an administration that has decided that it doesn't like a doctrine which protects religious organizations called the ministerial exception, which allows ministries to decide who its leaders are and to hire or fire whom they chose based upon their religious beliefs. The Obama administration has taken the radical position that that exception should go away and it should no longer exist, and the government should be involved in deciding who our ministers are, who our rabbis are, who our religious teachers are. And that, again, it's this just left-wing philosophy that they know better than us. They know better than the people at the ballot box, and they're taking their warped view of the Constitution and trying to impose it on the rest of us.
Jeff Mateer is our guest this morning, and for this edition of Five Questions, it's heard right here on KHVH Radio and also on HawaiiReporter.com. I urge you to log on today and every day. Well, we're coming to the end of our line of questions here, Jeff, but I did have one more and maybe a companion to that. One of it has to do with the absolute delineation, or I take that back, definition of separation of church and state, and the fact that it's invocation at every turn. Whenever there's a conversation about religion and government, public versus private, separation of church and state is always inevitably invoked. So if you could clarify that for us, and also a companion to that would be a redefinition of the legal jurisdiction of the federal government regarding states. And a specific example could be Obamacare as a point of conversation. Could you help us understand both of those for us, please?
Sure. Now I'll start with the term wall of separation of church and state. I've got a copy of the Constitution in front of me. I've got a copy of the First Amendment in front of me, and I think some people may be surprised to learn, I'm sure you're not, but that phrase is not in the First Amendment. It is nowhere contained in the religion clauses or anywhere else in our Constitution. So it is not there. It comes from a letter that Thomas Jefferson sent to the Danbury Baptist of Connecticut back in the early 1800s after he had become president. It does not come out of the founding of our country. In fact, when the First Amendment was being framed, Jefferson was not not even in the United States. He was in France. He wasn't involved in the debates. And so I think it's, when we think about interpreting provisions of the Constitution, it's interesting to me that the ACLU and the left kind of has adopted this phrase that Jefferson used in a private letter in order to advance what they want the First Amendment to mean.
Right.
The First Amendment, and when we talk about the Establishment Clause and the Free Exercise Clause, was meant to protect citizens and churches from the government. It was never conceived by our founders to be used against churches and people of faith. And I think if we were sitting today with any of our founders and we told them where the Supreme Court has gone the last 50 years in interpreting the First Amendment and the religion clauses of the First Amendment, they would be astonished that the First Amendment is using to prohibit people of faith from expressing themselves in public, to prohibit people of faith from really engaging in the political process. So that phrase, separation of church and state, has just been it's been warped. And the good is that through judicial appointments, we're seeing judges get appointed to the bench who really do understand it. And Chief Justice Rehnquist, before he retired, said it was a misplaced metaphor. And I believe there are at least 4 judges now on the Supreme Court who also adhere to that the separation of church, that is not a true way to interpret the First Amendment. The First Amendment was clearly meant that the government would not establish a church. It was clearly meant to protect the free exercise of people of faith and institutions. So I think that's real important.
And I guess I just have to do this while we've got you, because I'm glad that we're and in getting back to that letter, it was the Baptists. They were saying, hey, listen, President Jefferson, you're not going to try and establish a church on us. We're free to worship as we please. There was still a fear that there would be an implementation of an official state church back in that time, wasn't there?
No, that's exactly that there was. I mean, because they had experienced it in the early days of the colonies, and the various states had actually adopted, and they did not want a national church, and that's what the Danbury Baptists of Connecticut, that's what they did not want, and they didn't want Jefferson to be involved in that, and he assured them that no, and again, it was protecting the church from the government. It wasn't protecting the government from people of faith.
So how is it then, Jeff, that we have the invocation of separation of church and state in policies that are determined? For instance, if it's in a school board will establish that you cannot have a scene of a nativity even as a project because it violates the separation of church and state. I mean, it's utilized constantly for those of us with faith that want to express it in a public place.
Well, in about 50 years ago, it was first used in a case in order to restrict the government from doing something that was perceived to send a religious message. And so since that time, courts, judges, the ACLU, Freedom from Religion Foundation, other groups, in pushing their agenda, which really is they want to remove religion from the public square. I mean, they've said it in their writings. That is their goal is to remove religion from the public square, and so they've keyed on this. They get like-minded judges who push this agenda that anything in public that promotes religion in any way must go. And what we've got to do, and what we've been doing at the Liberty Institute, is no, that's not a true interpretation of the First Amendment. It's a wrong interpretation of the First Amendment. The First Amendment was about making sure that I'm not coerced to do something, that the government can't tell me I have to go to this church, I have to give money to this church, things like that. It had nothing to do with the things that the left has done. So, there's nothing wrong with having Christmas. There's nothing wrong with having Christmas parties, like our Morgan case. There's nothing wrong with treating people equally and really not discriminating. I mean, where we've gone now, they've taken that phrase to basically discriminate against people of faith. When little Jonathan Morgan wants to hand out a candy cane with the legend of the candy cane, saying, "Oh no religious items, but everything else is fair and free."
Yeah.
Well, no, that's not right. That's discriminating against people of faith. That's what the First Amendment should protect, not cause the schools to prohibit.
Amen. And just briefly, I know I've kept you so much longer, and I appreciate you staying with us, Jeff, very, very much. Just very quickly, legal jurisdiction of the federal government regarding states. What is your definition there, and is there an example such as Obamacare that might usurp that?
Well, I mean, we've through the years we've got a federal government who wants to get in every area of our life, and they've ignored the 10th Amendment. And so if we don't take back our Constitution and we elect leaders who appreciate the Constitution from president on down, that understand that the states do have a vital role, and that the federal government doesn't have a right or responsibility to get in every area of our life. And I think healthcare is a prime example, as you've mentioned. For the federal government to mandate to the states or us as individuals what we have to do and not do, and again, that's contrary to our constitutional republic.
It has been a delightful conversation with Jeff Mateer of the Liberty Institute. He serves as general counsel. And again, Jeff, how about the invitation to visit the Liberty Institute?
Yes, anybody who would like to come by, certainly one way to do it is www.libertyinstitute.org. That if you're ever in the Dallas area, we'd love to have you come by our offices too.
You know what, Jeff? I thank you so very much. I hope we can have another conversation when I am sure more developments in the protection of the First Amendment is at stake. So thank you so very much.
I would love to do that. Would love to be in studio someday.
You know what? Come on over. The water's fine.
I have been, and I love it. I love it. I love it in Hawaii.
Well, we're right near downtown Honolulu, but you know what? Come on over and join us. We've got some beautiful islands.
You do.
Beautiful place. All the best, Jeff. Aloha, and thank you.
Thank you.
Bye
Bye-bye.
now.